So moving swiftly along, we've got our last speaker for this afternoon, and he is none other than Mr. Jason Nathu. He will be speaking to us about draft guidelines of social media etiquette for attorneys at law. Now, Mr. Nathu is an attorney at law with over 11 years post-qualification experience in Trinidad and Tobago. He is a tutor attached to the Hewing Law School in the General Legal Aid Clinic and the supervising tutor of the law school's Human Rights Law Clinic and Innovation, Technology, and Entrepreneurship Clinic. Mr. Nathu is a senior ordinary member of the Council of the Law Association of Trinidad and Tobago. He is an academic member of the International Trademark Association and a member of the Advisory Board of Street Law Caribbean. At the HWLS Legal Aid Clinic, his primary areas of practice are civil litigation, intellectual property, family law, and administration of estates. Prior to joining the staff at HWLS, he was an associate at the law firm J.D. Saley and Company, where he gained tremendous experience in the litigation and dispute resolution, intellectual property, and real estate departments. He holds a Bachelor of Arts in History from the University of the West Indies, a Bachelor of Laws from the said university, the Legal Education Certificate from the Council of Legal Education, and a Master's of Laws in Intellectual Property Law from the University of London. Please welcome Mr. Jason Nathu.
Okay, thank you very much, Maria. And, the thing is, we have a presentation lined up for you this afternoon, but a lot of it has actually been covered already very eloquently by both Judge and by Vani. So it makes my life very easy today. Basically, what I want to say is that the IT Committee of the Law Association has been working very hard. We are trying to put together some draft social media guidelines. Just waiting for the presentation to come up on the screen. Just bear with us 1 minute. We're just trying to pull up the slides. Right, so we've been trying to put together some draft social media guidelines, and we're making some progress, slowly but surely. But it's only through interactions like this, consultations with members of the profession, and getting the views from the bench, as we did with Justice Lucky today, and of course with practitioners, as Vani has shared with us, that we can actually put together a document that can be circulated. And what we thought we would do this afternoon is just discuss many of the things that have been showcased already today, but give some considerations for food for thought and see where we go from here. So this really is a conversation that we're opening and we're beginning. And I hope that some of the questions that we get today will inform how we prepare the code going forward, or the draft guideline going forward. So of course, we start with the Code of Ethics. And I think we've said many times this afternoon that when the Legal Professions Act was brought into being in 1986, that the internet and of course concepts like social media were never contemplated. There have been calls for reform of the Act itself, not just in terms of the Code of Ethics, but generally in terms of provisions of the Act. We've heard statements like the provisions on advertising are unconstitutional coming out recently. But of course, the code is still binding. And we know as lawyers that if a judgment, for example, is appealed, the decision of the lower court remains binding until further adjudication. And so it is with the code. The code is still binding. Even if we think it's unfair, or even if we think there are aspects of it that need to be reformed. So we just want to look at the code and see how it guides certain aspects of social media and throw out some considerations to think about and see how we can get the discussion going. So guiding principles. I think these are the guiding principles of the Code of Ethics. The duty of an attorney at law is to act with integrity. The duty of an attorney at law is not to compromise his independence. And the duty of an attorney at law is to behave in a way that maintains the trust and that the public places in members of the legal profession. So that guides how we behave not only online, but generally in our day-to-day lives. So let's talk a little bit about advertising. And of course, advertising is a very controversial topic. What are the code provisions that deal with advertising? We have Part A, Rule 7, which deals generally with unprofessional. It's unprofessional to solicit business by circulars or advertisements. Part B, Rule 5, that's we are not to attract business unfairly. And of course, there's Part B, Rule 6, which is the probably one of the longest sections of the Code of Ethics that deals with advertising, endorsements, comments on live cases, political advertisements, signage, business cards, and of course, those things must be in what they call a restrained and dignified manner, directories, etc. So we know what the code says. What are some of the guidelines? We've heard it already this afternoon, but just to say it again, be mindful of the things that you post, which may be construed as advertising. There's, of course, a duty to regularly review and remove where necessary the contents of your social media accounts. And of course, to be aware of the comments section on social media sites, which invite discussion, which invite interaction. And sometimes interaction can be a healthy thing, but we can also see where interaction can become problematic. So putting that into perspective, here are some considerations. And these are questions that we hope that people will think about and give the Law Association comments going forward, whether, if not in this forum, but certainly we invite those comments, and we will be putting out a call for comments on these things later on. So what is a personal and what is a professional social media account? We've heard about people talking about dual accounts for their personal lives and their professional lives, but then there's sometimes platforms that are personal in nature, while some platforms are professional in nature. Facebook, for example, versus LinkedIn. LinkedIn boasts of being a professional social media platform. But what does that really mean? Is it really a professional platform? Doesn't it still allow or facilitate what could be construed as advertising or endorsements? Are those things a violation of the Code of Ethics? So these are things to consider. We spoke about posting photos outside of the court. If you're posting a picture outside of the court with your robes, maybe on the day that you're called, nobody will construe that as an advertisement. But if you're on the steps of the Hall of Justice, you're shaking hands with a client, you post a picture of that online, what message does that send? So that's a question that we have to consider as well. Statements about the quality of your work. I'm the best attorney ever. I have so many years of practice. I practice in this area. I'm a specialist in this field. And those statements being made online, how does that impact on the code? And of course, testimonials from clients and colleagues. Now, there are sites like LinkedIn, again, which invite people to give endorsements or testimonials. But what about another platform and someone giving a testimonial on your behalf about how great of an attorney you are? Is there any violation there of the code as it relates to advertising? So these are open questions that we invite comments from our audience here and also from the online audience. And of course, we'll be soliciting this as well further as we go along in consultation. Let's talk about legal advice. So the general code provision, Part A, Rule 6, speaking about writing in public on legal topics. General guidelines. General answers to legal questions rather than specific tailored advice. People always are asking for advice online. So we as attorneys should really not try to answer every detail of a tailored question online, but perhaps give general information. And of course, we want to qualify that with a disclaimer. This is not intended to be legal advice for anyone. And of course, if you really should contact an attorney at law for independent legal advice. Don't rely on what is being said online. But is that enough? And here are some of the considerations again. Responding to a post on a specific legal question. Should we be doing that online? It happens all the time. I'm sure many of us have encountered positions where someone has asked for advice and we might be tempted to respond to it, or someone else decides to tag us in a comment on that post saying, could you please assist by answering this question? We know that the traditional media also reports on social media, and we see things that are happening on social media making the news. We see statements being made by attorneys forming the basis of newscasts in the 7 p.m. newscasts in the evening. So, of course, Again, what is private? If a journalist, for example, has access to something, or someone screenshots a comment that you might have made in what you think is a private capacity, that could end up in the traditional media. So again, we have to be careful. And should clients be friends or followers on social media? Another very murky, gray area, but something to consider as we go forward. Confidentiality. The code provisions on confidentiality, Part A, Rule 23.2, that we must scrupulously guard our clients' secrets and confidences. And Part B, Rule 15, never disclose information communicated to you in the capacity as attorney at law. I think in terms of guidelines, it's very self-explanatory. We all know the duties of confidentiality, but where does it become gray? Again, we heard Vani made that mention of a post where someone spoke about the magistrate not being present in court. But sometimes, and I have seen it, ranting about a client or a case online, this client came into the office today and said X, Y, and Z, or this happened in court. Should we really be doing that? Taking photos of pleadings where parties' names are identifiable. And I see this all the time on Instagram, on Snapchat stories. But we're seeing someone, I'm working very hard, I've been up all night, I've been doing X, Y, and Z. Bam, there's a screenshot of pleadings and the parties' names are identifiable. Compromising confidentiality. And of course, compromising your identity as well, but we'll get into that a little bit later. Or communicating with your clients in the public domain. So we spoke a little bit earlier about WhatsApp. I suppose there's a debate as to whether WhatsApp could qualify as social media. I suppose it falls within a general, a wide category of social media, but persons may communicate via public post to a client online. Is that really what you should be doing within the ambit of confidentiality? So something to consider as well going forward. The duty to the courts. So many provisions in the code. Part A, Rules 36.1, 2, and 3, to encourage respect and maintain respect towards the judiciary and to support the judiciary against unjust criticisms. Part B, Rule 19, conduct must not be undignified or degrading to the court or the profession. And Part B, Rule 20, no false accusations to be made against the judiciary. Some guidelines. Making a social media post which is in any way undignified or discourteous towards the judiciary is not permitted. So again, our example about the anonymous lawyer posting about the magistrate not being present, waiting, wasting half the day, feeling frustrated. We've seen it. Some of us might have been tempted to do it as well. Or any attempt to influence or gain favor with the judiciary via social media is not permitted. So how does that translate into context? These are the questions. Again, we talked about ranting about what happened with a client. What about ranting about court, or what happened in courts, or ranting about how a judge treated you or dismissed your application, or a magistrate, for example, things that actually happen, posts that we see from time to time. And again, we think that it's within a private context, that it's to a limited audience, but is it really a limited audience? Is it really a private audience? So these are questions that we really have to consider going forward. And what about interactions with friends and followers who are judicial officers? And not only are we speaking about a judge or a magistrate, but what about a JSO or a secretary to a judge or anybody who works in the judiciary who may be affiliated with the administration of justice? Our interactions there could be perceived to be in breach of the ethical rules. So we have to consider these things going forward as well. And of course, other factors. And I'm not going to be very long. This is our last slide. But really, we know of there are rules when it comes to interacting with jurors. But now social media has made it so much easier to find out about jurors online. You could type in the name of a juror and get their entire social profile. We spoke about Carnival and social media, and I don't think there's anything else for me to say on that because both Judge and Vani went into Carnival and social media at great length this afternoon. But what about identity theft and fraud? We're hearing about all these fraud cases at the conveyancing, the land registry, for example, of these being prepared by attorneys who have passed on. But yet we are seeing attorneys, young attorneys in particular, taking photos of their pleadings, of their bar number and their name, and posting those on their stories, doesn't that open you up to the chance of your identity being stolen, or for some document to be created by some unscrupulous person using your identity, using your bar number that you've publicly put out in a fraudulent manner? So these are some of the questions. These are the beginnings of our social media guidelines. They are not yet final, but we really are hoping that with your comments, we will be able to distribute something in the very near future. So I'm just going to open the floor now to any questions that anyone might have. And Vani, I'm sure we'll get questions to both of us here.